I'll give you one example. I had a client that was referred by somebody else. They were the CEO of a private company, family-owned company, very profitable. The company had been founded in 1957 by the CEO's father. The father had passed away, and before he passed away, he put all of the shares in an LLC, and then he took all the units of the LLC and he spread those across 6 different trusts. The mother was a trustee on all 6 trusts, and then there were other trustees on the trust. But the CEO, who was the son, did not own a single share. If the mother died, the trust would be liquidated 50-50 to him and his brother. But his brother had nothing to do with the company. And he was concerned that if the brother then had a say-so, 50-50, that it might compromise the management of the company. So he wanted 1 share so that he would always have at least 1 more share than his brother, so that he would always be able to control the decisions for the success of the company. His mother wouldn't do it because she didn't want to create an issue with the brother. The trustees wouldn't do anything the mother didn't want to do. He went to 2 major law firms, and they said there's nothing you can do unless the trust gives you a share or sells you a share. So I said, okay, send me a check and send me all the corporate documents, minutes, certificate of incorporation, bylaws, resolutions, everything you have, going back to the beginning, and let me see what I can do. I studied everything. A little while later, I sent him an email, and I said, if you send this email to your mother and the trustees of the other 6 trusts, you will own outright, without paying a dime, you will own 33.3% of the company outright. And there's nothing they can do about it. He went, whoa, that would cause a couple of problems with the family. So it turns out he went back to his mother. He said, look, I don't want to have to do this, but I need to know that I will control the company. They negotiated something that he was happy with based on his ability to do that. What gave him the right when 2 major law firms said there's nothing he could do? Because they didn't understand governance. They didn't understand business to the degree that they needed to. There were things they didn't notice. There were questions they didn't ask. That in the formation of the company, there were certain, I won't get into detail, but there were certain loopholes in the formation of the company that allowed him as the CEO and as the only member of the board of directors literally to give himself 1/3 of the company that wasn't already given. There were 200 shares in the trust. He was able to give himself up to 100 additional shares that had been authorized but never issued. And there was nothing anybody could do about it. But that's just one of a variety of different issues that can come up. Thank you very much for watching the video. I really appreciate your time. I get a lot of satisfaction out of being able to educate private company management and owners on some of these issues. If there's anything in these videos that trigger your thoughts on a particular topic or issue that you're having, feel free to reach out to me for a quick phone call. I'm more than happy to evaluate your situation at no charge. If you'd like to reach out to me, you can do so by sending me an email at dennis@caganco.com. And you can also get more information on my website, caganco.com, including a variety of articles and videos on similar subjects.